Good afternoon, everyone, and thank you for joining this Ius Laboris webinar. My name is Florence Duhon, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different members of Ius Laboris. Before we kick off the session, I would like to clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab to send your question to us, and the panelists will answer as many as they can. You can, of course, also reach out to the panelists by email after the webinar. Now, regarding the slides, they will be available on our website along with the recording after the webinar. I will now turn over to Catherine Leung from Lewis Silking in Hong Kong to begin the session. Catherine, the floor is yours.
Thanks, Flo. Good afternoon, everyone. I am Catherine Leung from Lewis Silk in Hong Kong, and I will be your moderator today. Welcome, everyone, to our session today on restructuring in the APAC region. We're going to be focused on current trends and best practices in restructuring, redundancies, and collective dismissals. For those unfamiliar with Ius Laboris, we are a global alliance of law firms specializing in employment, labor, immigration, and pensions law. We have over 1,500 HR lawyers spanning across 57 countries. So today, we have speakers from 9 different locations in the APAC region, including my colleague Gladys Ching, who is a managing associate in our Hong Kong team. We also have Crystal Leonard from Australia, Bo Zhao from China, Gagan Verma from India, Yukiko Imazu and Yuka Camillo from Japan, Stel Alagaratnam from Malaysia, Peter Keeley and Hannah King from New Zealand, Desmond Wee from Singapore, and last but not least, Chris Mendel, who is joining us today from Korea. So we've got 90 minutes together today with a ton to pack in. So without further ado, let's jump right in. Starting with Gladys from Hong Kong. What are the key considerations and recommended practices for companies when undertaking restructuring?
Thanks, Catherine. In a restructuring exercise in Hong Kong where employees may need to be dismissed, employers should first consider whether any of the impacted employees are under protected circumstances. Under Hong Kong law, if the employee is on statutory sick leave, statutory maternity leave, or if there is an ongoing employee's compensation claim for work-related injuries, or if the employee is participating in proceedings in connection with enforcement of the employment ordinance, then the employer is prohibited from terminating the employee's employment. It's also unlawful in Hong Kong to terminate employment on the ground of breastfeeding, disability, family status, marital status, pregnancy, race, sex, or by reason that the person is serving as a juror or participating in trade union activities. Doing so would amount to unlawful discrimination in Hong Kong. So, if there are any employees under protected circumstances, separate advice on how to handle their exit would be required, as the actual facts and circumstances of the employee would impact on the exit strategy. In addition to that, employers should also consider the length of notice required to terminate the employment and whether they would like employees to serve the full notice period or make a payment in lieu of notice, or a mix of both. Employers should then also consider the tenure of the impacted employees, as employees who have at least 2 years of continuous service with the same employer would be entitled to a statutory severance payment in Hong Kong. Finally, employers should also review the employment contracts of the employees to determine if there are any contractual payments which need to be paid out upon termination on top of all the statutory severance payment and other legally required payments. In terms of best practice, to ensure consistency in the message delivered to employees, employers may wish to prepare a template termination letter and settlement agreement, which can be tailored to each impacted employee. There's actually no statutory consultation requirement in Hong Kong. However, the employer will need to notify certain authorities or third parties of the termination, such as the Inland Revenue Department. So employers should ensure that all notifications are made in a timely manner.
Thanks, Gladys. We're going to come to consultation requirements in a second because I know there are certain countries with consultation, but first, I'm going to turn to Japan. I understand that it's very difficult to dismiss employees in Japan. So turning to Yuka, what are the key legal considerations and recommended practices for companies when undertaking restructuring in Japan?
Yeah, well, one of the key legal considerations is how to reduce the workforce while avoiding dismissals and minimizing the risk of disputes. In Japan, dismissal for restructuring purposes is extremely difficult. This is because the validity of the redundancy dismissal must be carefully and strictly assessed based on 4 key factors. First, there must be a strong business necessity for workforce reduction. And second, the company must exhaust all possible options to avoid dismissals. Third, the selection of employees for dismissal must be fair. And fourth, the procedure itself must be fair and appropriate. Among these factors, demonstrating a strong necessity for workforce reduction is particularly challenging. For example, unless a company is facing severe financial difficulties, such as consecutive years of losses that threaten its survival, it is generally difficult to justify dismissals. Even closing the unprofitable divisions while the overall business remains profitable is unlikely to satisfy this factor. If a company forces dismissals, there is a high likelihood that dismissed employees will file lawsuits. If the company loses, it could face significant financial consequences, such as paying back wages and reinstating employees. Additionally, legal disputes relating to redundancy dismissals often attract media attention, posing reputational risks for the company. These potential risks further emphasize the importance of avoiding dismissals whenever possible. To address these challenges, the recommended practice for mid to large-sized companies is to offer voluntary resignation programs to all employees or to those in specific departments targeted for restructuring. This typically involves offering severance packages calculated either through a standard formula or a fixed amount, and inviting employees to resign voluntarily. Alongside such invitations, companies may also individually approach employees, such as those with poor performance, and encourage them to apply for voluntary resignation program. For smaller companies, direct discussions with employees about resignation are more common, but fairness remains essential. Even if a company instructs employees to keep the conversation confidential, word often spreads. So, ensuring fairness by offering consistent severance terms to all targeted employees helps maintain trust and reduces the likelihood of disputes. In summary, by prioritizing voluntary approaches, companies can effectively manage restructuring while minimizing both legal and reputational risks.
Thank you, Yuka. Let's turn our focus now to China. So, Bo, what are the key legal considerations and recommended practices for companies when undertaking restructuring in China?
Yeah, thanks, Catherine. So, well, I think one of the main features for termination in China due to redundancy is that redundancy itself is not a legal concept under Chinese law. And also, as a lot of the audiences may have already known, that in order to terminate employees in China, the company needs to rely on one or more of the mandatory grounds provided by the law. Therefore, the main challenge to terminate due to redundancy is that you need to figure out which of the mandatory grounds would be proper for the circumstance. And oftentimes the redundancy is based on actual business reasons, such as restructuring in the organizational chart of the company, elimination of positions or business units, or closure of departments, or even the legal entities. And depending on the difference of the business reality, the applicable termination grounds, mandatory termination grounds may include 4. So number 1 is termination by mutual agreement between the company and the employee. Well, this actually doesn't technically require any specific business reason, and you can start the termination discussion with the employees at any time for any reason. So the reason is actually not for legal purpose, but it is more for business purpose, so that you can have a start point to talk with the employees. And the second is termination by the employer due to a material change which seriously affects the performance of the employment contract, while the employer and the employee cannot reach an agreement to amend the current employment contract. The challenges with this ground is that because you need to have a negotiation with the employee for amendment, normally, namely by offering him or her an alternative position. But in reality, in most cases, you don't have any alternative positions to be offered. Well, the third ground is termination by the employer due to closure of a legal entity. Well, this will be the most straightforward ground for termination, but it has more business challenges, because in most times companies would not want to close down a legal entity. Instead, they would want to keep the legal entity, even though sometimes they don't have any active business operation. They still want to keep the entity because things might change in the future. And the third ground would be the collective termination or mass layoff by the employer due to serious operation and financial difficulties. Well, this often requires the company to prove that they have really faced business difficulties for several years. For example, you may need to provide financial statements as evidence. And another challenge with this ground is that you need to file your layoff plan with the local government. While in a lot of times you may face difficulties and obstacles in fulfilling this obligation. So because of the challenges and uncertainties faced by the unilateral termination grounds, I think in practice the most adopted approach would be a combined strategy, meaning we do termination by mutual agreement with the employees, while at the same time we also prepare for a potential unilateral termination, which could be used as a backup plan. Yeah, thanks, Catherine.
Thank you, Bo. It's interesting to know that redundancy is not strictly a legal concept in China, but there are still ways to exit the employment, usually by way of some sort of mutual agreement, and probably with the provision of some sort of severance. Thanks, Bo. And turning now to Malaysia, Sal, what are the key legal considerations and recommended practices for companies when undertaking restructuring in Malaysia?
Thank you, Catherine. Happy to jump in here. So under Malaysian laws, all employees have protection against unjust dismissal from day one. So even when an employee is let go on the ground of redundancy or is retrenched, employees can commence, and they generally do commence, unjust dismissal actions. Now, just like most of the other countries, there are requirements in terms of minimum termination notice period, severance benefits, as well as prior notification to the authorities. But complying with all that is not sufficient to protect the employer from legal risks. The court, if an a court which is hearing the unjust dismissal action is under a duty to examine whether the redundancy in itself is genuine. And if the answer to that question is yes, the court will then consider whether the employees who were terminated were selected in accordance with applicable laws. And the burden of proving all this is on the company through witnesses that it would have to call. The decision maker must attend court to justify the decision and also produce documents to support the reasons provided for redundancy. So this may even extend to financial records. Selection of employees is often a sticking point with clients because it must be done in accordance with a set criteria. And this includes terminating foreign nationals before terminating local employees, assuming they're doing the same job role. And another challenging aspect is that we have the rule of last in, first out, which means that the employee who has the least seniority or years of service within the company has to be the first one to be let go. Another interesting aspect under Malaysian law is that a mutual separation agreement is not always enforceable. So even when parties have signed a mutual separation agreement, the court will consider whether that agreement was signed by the employee under duress or any form of pressure. So typically the courts have held that if an employee has been told that he or she is going to lose their job anyway, then whatever they sign on to is really without free will.
Wow. I mean, I'm going to go off script here for Bidsell. Are employees, do they readily go to the courts in Malaysia? Because what you've said is even if you've signed, I get the impression in China, if you sign an agreement, a settlement agreement, then it's done and dusted. But that doesn't completely shut the doors in Malaysia. They could still bring a claim. So how prevalent is it for employees to bring claims against their former employers?
Oh, very, very prevalent, unless they are really happy with the package that they've received.
So the more generous, the less likely it will be.
That's right. That's right. And also, you know, the more respectfully they've been treated, you know, if they've just been told at 11 a.m. that they've lost their jobs and they have to clear their desk within 30 minutes, you can be pretty sure they're going to take you to court.
Well, let's turn to India. Gagan, India is a country where restructuring can vary across the different states in India. So turning to you, what are the key legal considerations and recommended practices for companies when undertaking restructuring in India?
Thank you, Catherine. You are absolutely right. What makes India particularly interesting is how restructuring requirements can vary significantly across states because of our demographic position, the various cultures people follow. But what is important is that the employer has to maintain certain core principles while implementing redundancy. The foundation lies in properly understanding how employees are classified under Indian law, determined by examining the predominant nature of their duties, not designation or titles. This is one big mistake usually the employees do. For instance, an employee might have a senior title and good compensation, but if their core day-to-day functions are technical rather than managerial decision-making, they could be classified as a workman and would be entitled to statutory compensations while they are being retrenched. So for establishments employing 100 or more workmen, prior government approvals would be required for retrenchment. This is emanating out of the Industrial Disputes Act. However, even where such approval requirements do not apply, usually for multinational companies with Indian subsidiaries with backup office operations with thinner workforce, such companies need to ensure proper documentation of business reasons why they are making this redundancy, and also follow appropriate procedures for different employee categories, which I have described. This leads us to what we are seeking work effectively in practice. That is offering employees the option to resign voluntarily through mutual separation agreements. This is very common practice just to mitigate the risk of any potential litigation or a dispute after retrenchment, because as many other of our colleagues have said that in any case, if the person has no option but to sign these termination documents, this is usually could be considered as not at will. So company typically structure these agreements to include statutory dues and also additional ex gratia payments, ranging between 1 to 3 months salary based on factors like the length of service and market conditions as well. So they could lead up also to give higher ex gratia payments to satisfy the employees being terminated. So the reason this approach has proven particularly effective in India is that it helps preserve employees' future employment prospects by avoiding any adverse remarks on their service records. This is very important factor while this message is being conveyed to such employees. The key to successful restructuring lies in combining proper documentation with the sensitive handling of separation discussions, as other colleagues of us has also discussed this. So clear communication about separation terms and maintaining professional dignity throughout the process has consistently proven effective in achieving smoother transitions while mitigating potential disputes.
Thanks, Gagan. Chris, turning to you, I understand that similar to China, there is no right to terminate due to redundancy. And similar to Japan, Yuka shared earlier, it's a very difficult jurisdiction when it comes to dismissal. So for Korea, what are the key legal considerations and recommended practices for companies when undertaking restructuring? Thanks, Chris.
Thanks, Catherine, and hello, everyone. You're exactly right. Korea is a very difficult jurisdiction for any kind of terminations and especially downsizing. The big challenge in Korea is that companies generally just don't have any right to terminate employees for redundancy at all unless they have what's called an urgent business necessity. And so in that respect, it is similar, as you said, to Yuka's explanation from earlier about Japan. And there are only very limited exceptions to these kinds of strong employment protections in Korea, such as where employers have fewer than just 5 employees in Korea, or they completely close down their business. And an urgent business necessity is a very high standard. It's as tough as it sounds. It's very hard to convince courts that there is an urgent business necessity unless the business is in very dire financial trouble. Yuka was talking earlier about years of losses, and that's typically the kinds of facts that courts expect in Korea as well. And dismissed employees have a right to get their jobs back. It's not just a question of paying them. And so that's fundamentally different than a number of other jurisdictions where companies have a basic right to restructure their workforce if they choose to do that, as long as they follow certain procedures or make certain redundancy payments. In Korea, it's a key threshold consideration from the beginning whether unilaterally terminating employees is even on the table at all. And often it just isn't. Where the Korean business isn't losing money, isn't in dire financial danger. For example, there's just a global decision to cut costs and restructure the workforce globally. There's often just no plausible case for an urgent business necessity, and unilateral termination is just not going to be legally defensible. And so unilateral termination isn't viable, restructuring generally has to be handled via buyouts, which are agreed with the employees, and they can't lawfully be terminated unilaterally. And so in those cases, you basically have to rely on effective communications and engagement with the employees, and often consider backup measures like reassigning redundant employees to new roles. Where there is a plausible case for unilateral termination, you could make a decision to structure a project with dismissals as a last step. But there are significant procedural requirements as well for unilateral terminations for redundancy. And I'll just briefly mention those. They are actually somewhat similar to the Japanese requirements as well. So there's a requirement to make efforts to avoid dismissing employees, and that basically requires that the employer try to exit most employees via negotiated buyouts, and dismissal is only used as a last resort. And then there's an expectation that other efforts will be made as well, and those can include things like wage and hiring freezes, reduced working hours, and so on. Fair selection criteria also have to be used, and at least 50 days notice to the workforce and a good faith consultation with an employee representative are also required, although typically it takes actually longer than 50 days in practice. And finally, a last consideration I'll mention is whether there is a CBA that imposes more obstacles. So sometimes companies have a union and they have a CBA that with stronger restrictions on downsizing. For example, they sometimes have a provision that requires the union's consent before layoffs can be employed. Unions like those kinds of provisions and push for them in CBA negotiations. And once you've agreed to that, it's very hard to get rid of it. So you always have to check whether there is a CBA and what's in it. And if it's a tough CBA, it can make things even more difficult and increase the legal risk significantly.
CBAs is that collective bargaining?
Collective bargaining agreement, yeah. Sorry about that.
Are they common in Korea?
Yes, especially for larger companies or companies with manufacturing workforce. Although, unlike the US, there are some industries here with a pretty heavy unionization rate that is kind of weird to an American like me. For example, financial services have a lot of union members. It's kind of weird for an American to think of bank employees all unionizing, but that's very common here.
Oh, that's interesting. So similar to, I think it was China, if there's a closure of the operations, then it's more straightforward. And you also mentioned if there are less than 5 employees. Is it 5 employees for the Korea entity, or is it 5 employees with the group? Or
it's funny that you should ask that. We actually just published a newsletter on this not that long ago because there was a big Supreme Court decision clarifying this. For a long time, there was some ambiguity about this, and there were lower court decisions that counted overseas HQ employees because the local presence wasn't independent enough. But the most recent precedent from the Supreme Court clarified that you only count the local employees, and that overseas employees who are not subject to Korean law shouldn't be counted. So that actually has been a helpful development for companies that have a very small outpost in Korea.
That's great. Thank you, Chris. Now let's turn to Singapore. Desmond, what are the key considerations and recommended practices for companies when undergoing restructuring in Singapore?
Thanks, Catherine. Maybe just as a starting note, if ever there was a counterfoil of a jurisdiction, having heard all my colleagues in terms of managing and restructuring, I would certainly put Singapore as a leading candidate. Hearing the various jurisdictions and in terms of how many of these jurisdictions will either as a matter of law or as a matter of policy put in place protections and controls when it comes to downsizing, Singapore takes a much lighter touch when it comes to regulating companies who go into such restructuring exercises with the view of downsizing or right-sizing its employees. Firstly, there is very little legislation that governs the issue of redundancy. there is really only one particular section in the Employment Act of Singapore that even addresses an issue of redundancy, and that's drafted in a double negative. So you kind of don't need to worry about that. Secondly, redundancy from a legal perspective has no statutory definition, which means that you look at it from a very practical perspective. Whenever you decide whether a role is being made redundant or whether a role is redundant or not, it is essentially looking whether the role will cease to exist, whether by way of a restructuring or by way of a decision of the company to take it away. And effectually, that is the position. That's it. You would then decide that when you are going to terminate the employee, similar to what Gladys has said in Hong Kong, you will actually look at the termination process. You follow the termination process that is provided in the contract of employment or based on company policy. Now, once you have followed that termination process, in a sense, that reason for the termination is because of redundancy. That gap on how you deal with a redundancy situation is then filled by not law, but an area of what we would describe as guidelines and advisories issued by a body called the Tripartite Alliance. And those of the participants in this seminar who is very familiar with Singapore will know that this is a body that comprises 3 organizations. Firstly, the Ministry of Manpower. Secondly, the National Trades Union Congress. And thirdly, the Singapore National Employers Federation. So what they do is that they come together, forming the Tripartite Alliance, and they issue guidelines and advisories that will actually encourage best employment practices amongst Singapore employers. And while these guidelines and advisories have no force of law, in other words, for companies whose employees, directors, management, you probably will not be hauled up to court, you will not be charged, you will not be put in jail. So that's the good news. But essentially, what happens is that it has the power to investigate and to direct companies to explain why they are not following such guidelines and advisories. And if for whatever reason they do not feel that the explanation from the companies is good enough, they have the authority to impose administrative penalties. The main one that really hurts companies the most sometimes is really the prevention from applying for work pass privileges. Having said that, I've had clients who have had to downsize or eventually exit Singapore would turn around and tell me, well, if we're leaving Singapore, it kind of doesn't really make it any worse. So that's something to consider as well. Now what happens is that I put this in terms of context because there is a particular advisory that recommends a payment of a redundancy amount of anything between 2 weeks to 1 month for every year of service. So again, if I reiterate, whilst there is no statutory obligation to pay redundancy, there is a guideline that recommends a range. And if you don't follow that range, you'll probably get a knock on your door at midnight. Actually,
gosh.
I'm joking, not midnight, maybe about 10 p.m. And the reality is that because of that, we would generally recommend to clients, look, if you can, this is actually a guideline that kind of represents overall the policy thinking of the ministry, the regulator. And where possible, there is something that as good corporate citizens, companies should try to adhere if you can. The advisory also provides other recommendations, very similar to what some of what my other colleagues had discussed, where in their particular jurisdiction, it could be as a matter of law. But in Singapore, it is recommendation in terms of you have to be fair in terms of determining your criteria. You have to make sure that it is objectively defensible. I will, however, say that again, because these are recommendations, they don't have force of law. Issues like the last in, first out rule that Sal had actually shared with in terms of Malaysia doesn't exist in Singapore. So generally, just to summarize, when companies actually go into such restructuring exercises, it is not so much the law that will cause you concern. It would be how it is perceived that you have followed these guidelines and how you have actually implemented these procedures and these thinking, so that would get you a much smoother path as you go on the exercise. Thanks, Catherine.
Thanks, Desmond. Just staying with you, Desmond, just one follow-up question, if I may. We mentioned that redundancy also for Singapore is not a legal concept. There's no legal definition of redundancy. However, the guidelines that you've shared there, there's guideline on how much severance should be paid or retrenchment sum should be paid. Do companies generally tell their employees that they are being made redundant, which triggers the retrenchment payments, or how does that, what happens in real life?
Thanks for the question, Catherine. That's a very interesting perspective, because essentially you're absolutely right. From a statutory and from a legal perspective, there is no such definition. That there's no such provision in terms of what you call redundancy. So if you look at it from that perspective, redundancy is essentially the reason for your termination. The legal trigger is in fact the termination. And it follows on from there that if you do then make redundancy as the basis for your termination, then the advisory would then follow. Generally speaking, we would recommend to clients that when you are actually seeking to terminate employees by reason of redundancy, that you do share it with them, because the way you manage a redundancy scenario is very, very much different from how you would terminate by giving notice, or how you would dismiss a person for misconduct. And again, because there are multiple repercussions in terms of how you manage the employees and how the acceptance of the decision, it is normally the case that this would be disclosed to the employees.
Thank you, Desmond. Peter, turning to you. What are the key legal considerations and recommended practices for companies when undertaking restructuring in New Zealand? You're on mute.
Thank you very much, Catherine and team and participants. A pleasure to be here. The first point is that in New Zealand, businesses and employers do have the right to restructure. They can restructure, but there's got to be a genuine business reason, and the employer has to follow certain procedural requirements. And it's really the procedural requirements that we find that surprise our international clients, and that can present the greatest challenge. And the point that I want to emphasize and highlight in terms of New Zealand law is the obligation to consult with potentially affected employees about a proposal to restructure, and the employer in engaging in that consultation, it's got to do with an open mind, and it has to do so under our statutory obligation of what we call the duty of good faith. And what does that duty of good faith mean? Well, what it means is that both parties, but in terms of who we deal with, largely the employer, they have to be active and constructive, and responsive and communicative in a restructure situation. So where we find that employers often make a mistake is that they will say, it's already been decided, but we'll go through a process anyway. No, you have to, before you make the final decision, you've got to consult, you've got to tell the employees that might be affected exactly what is proposed, give them all the relevant information, and most importantly, give them the opportunity to comment on that information before a decision is made. And I should add, consultation is not equal to negotiation and agreement. It's about saying this is what we might do. What do you think? Give us some feedback. So to conclude, I can summarize the obligation for two important themes for New Zealand anyway. Number one, there can't be any predetermination. You can't go and say in colloquial terms, you're redundant. Now I'm going to tell you how we're going to go about it. There can't be any predetermination. So you've got to prepare a plan, and that's where we fit in as legal advisors. And it's important to speak to us before you start the process, not after it. And secondly, those disclosure obligations, preparing the proposal, they can be a bit onerous and cumbersome, and that's where it's important to talk to us as human resource or employment lawyers beforehand as to what a proposal might look like and what an opportunity to comment it might involve.
Thanks, Peter. Last but not least, let's turn to Australia. Krista, what are the key legal considerations and recommended practices for companies when undertaking restructuring in Australia?
Thanks, Catherine. Look, very similar to New Zealand, probably comes as not much of a surprise there, but in Australia, it's important to be aware of certainly the consultation obligations. There's sort of two tiers of employees when it comes to restructuring considerations in Australia, those that are covered by our modern award system and our enterprise or collective agreements, and those that are not, so typically managerial employees or senior employees. And for those that are covered by the award system or have a collective agreement, then as soon as a definite decision has been made around the need to make changes to an organisation structure, there is that consultation obligation that comes to play. That consultation obligation also has a requirement that employers offer at-risk employees a meaningful opportunity to raise potential alternatives, reasonable alternative positions or ways to perhaps do their role differently in order to maintain their employment before the definite decision to make that position redundant is made. And if that consultation process isn't properly followed, then there's a reasonable alternative position, but it isn't offered to the employee, then the employee has rights within Australia to commence typically an unfair dismissal claim in the Fair Work Commission, and they can assert that the redundancy was not a genuine redundancy. So again, there's the very similar themes around there needing to be a genuine business reason for it. And perhaps the broader issue to flag, Catherine, is that the involvement of trade unions in Australia, particularly in industries such as blue-collar industries, but also the finance industry to some extent, when it comes to internal processes relating to restructures. And really that can make it a little more complex when you're planning a restructure. Those collective agreements I mentioned earlier typically require relevant unions who are covered by the agreement to be notified in relation to any proposed restructuring that may impact the roles of their members. And certainly we've had a raft of changes in Australia over the last couple of years, which have been designed to increase the rights of unions and union delegates or representatives in the workplace to represent workers in that consultation process or where there's major workplace change, including, for instance, to rosters and working arrangements. So, of course, where the need to restructure is clearly defined and the business rationale is objective and the company has a clear structure on how it's going to approach that consultation process and has done an assessment around any reasonable alternative roles that employees who are at risk can perform, then that process will be relatively smooth, and where an employee is genuinely redundant, then that risk of litigation is certainly minimised.
It seems like to implement a restructuring or redundancy in Australia, you have to really plan this out in terms of timeline in advance, because you have to go through all those various steps, and also to deal with, to be in correspondence with the trade unions and make sure that's all ironed out before the dismissals can proceed. So keeping to the theme of consultation, what are the typical steps that an organization must take to fulfill the the consulting obligation?
Yeah. Well, again, it will differ, as I said, as to whether that employee is covered by a modern award or a collective agreement. Certainly, when it comes to senior employees, there really isn't any legal requirement to consult, although certainly it's best practice to do so. But certainly for those that are covered, which is the majority of workers in Australia, then there are absolutely steps that are mandated in relation to that consultation process. Typically, that requires notification in writing to the employee and any union representative where relevant, to notify the affected employees that they are or potentially impacted by the proposed changes. And that requirement, as I said, must happen as soon as practicable after a definite decision is made. So to go to your point, Catherine, when we're working with clients on restructures, it's all potential restructures, and there isn't a definite decision until you're ready to go and you've got your ducks in a row, so to speak. Secondly, there must be certain information that's given to employees at that time in writing. The employer must set out the impact or the proposed impact of the change and discuss mitigation measures, what they are doing. And that again goes to whether or not there's any reasonable alternative employment opportunities in the company or in any related entity that's reasonable. And then, just like Peter said, in New Zealand, we must genuinely consider feedback or suggestions, and that has to be a genuine consideration, notwithstanding that decision's been made already. So there is, you're right, some steps, and we do very much encourage the process to be well structured and thought out ahead of time. That not only helps minimise risk of litigation through the channels such as an unfair dismissal jurisdiction, but also helps minimise the psychosocial impact on employees and avoids or minimises claims that the employee has been adversely affected from a psychosocial perspective, which is certainly a big thing at the moment in this jurisdiction here in Australia.
Thanks, Krista. And to Chris, what about Korea? When consulting with employees about a redundancy proposal, what steps do you have to take in Korea to meet this obligation?
Sure, Catherine. So just to clarify, in Korea, formal consultation is only required when you're doing unilateral termination for redundancy. As I mentioned earlier, that's sometimes just not possible, and downsizing has to be done through buyouts. In that case, there's no legal requirement for a consultation. But if you are doing unilateral terminations, then there is a consultation requirement. It has to be with an employee representative. If there is a union representing a majority of employees, that's the representative. And if there isn't one, it's an ad hoc representative that has to be chosen by the employees. And the actual consultation requirements are not that specific. It's mostly about sort of showing good faith and engaging with the employee representative. There are some specific requirements, though, particularly the consultation has to address the efforts the employer makes to avoid dismissals and the selection criteria for redundant employees. But otherwise, it is mostly just about engaging, having regular meetings, listening to feedback, and so forth. If there's no involuntary termination, if it's just buyouts, like I said, there's no consultation requirement. But practically, of course, you still have to engage with the workforce, have a good communications plan, and persuade employees to accept the offer. And then if there's a union, there can always be special, heightened consultation requirements under the collective bargaining agreement.
Thanks, Chris. Turning to Japan quickly, what What sort of timeline do we look at? Because also Japan is a very difficult jurisdiction to terminate, almost virtually impossible. So when we're looking at a voluntary resignation, what's the general timeline for a voluntary resignation program, or ways that we can encourage resignation by employees in Japan? Yuka or Yukiko?
Yeah, thanks, Catherine. The timeline for voluntary resignation program varies, so it's different depending on the company's size and approach. So generally speaking, mid to large size companies take about 2 to 3 months at least from announcement to completion, while smaller companies with direct discussions may complete the process within 1 to 2 months at least. However, the more time employees have before the resignation date, the easier it is for them to search for new jobs, making them more likely to agree to voluntary resignation. So, yeah, generally speaking, it is advisable to allow at least 3 months before the resignation date, and if possible, a period of 3 to 6 months for a smoother transition.
Okay,
yeah.
So 3 to 6 months before to start the process.
Yeah, up to the resignation date.
Great, thank you, Yuka. Turning to our next question, which is focused on Australia, Malaysia, and New Zealand. And we briefly touched upon this earlier, but is there an obligation to consider an alternative position or role or redeployment for an employee whose job has been disestablished? So perhaps I'll turn to Hannah King first from New Zealand.
Thanks, Catherine, and hello, everyone. Look, in New Zealand, there is a clear obligation to redeploy an employee whose role has been disestablished into a vacant alternative role, even if that employee is not the best person for the vacant role, and even if they need a reasonable amount of training or upskilling. Now, this duty to consider redeployment continues throughout the employee's notice period, right up until the moment the employment ends. And failure to properly consult on or consider redeployment will almost always result in the redundancy being deemed unlawful. The issue is often litigated, and we've had a number of recent decisions from our courts confirming that position.
Difficult. Thank you, Hannah. What about Krista for Australia?
Yes, certainly the situation is very similar to the one that Hannah's just described from New Zealand, and where there is a reasonable alternative position and an employer hasn't offered that, and the same factual matrix in terms of it doesn't matter if they're underperforming or they're not technically the right person or the best person for the job. If they've got the skill set to enable them to perform that role, they must be offered it. And if they're not, then that results in the redundancy if challenged being deemed not a genuine redundancy. That means that employers do need to actively consider and identify, where possible, suitable alternative positions. The only thing I'd add to that from the New Zealand perspective is that also that requirement, and I mentioned this earlier, is not only in the employer's enterprise, but in any associated entity. And of course, it needs to be reasonable. So presumably and usually within the same city or general geographical location. But if there are related entities or other businesses that form within that related entity structure, then that it's broader than just the enterprise in which they're employed. And I'll just make that distinction again, that does not apply for senior or non-award covered employees, although obviously it's good practice if you want to retain somebody who does have talent and knows your business to do that.
Thanks, Krista. And staying with the same question for Malaysia, Sal, is there an obligation to consider an alternative position or role or redeployment for an employee whose job has been disestablished in Malaysia?
So by now you would have figured that in Malaysia, the laws are very much aimed at protecting employment. So the general theme really is that there is an obligation to retain employees in employment to the extent that is possible. So yes, the answer to your question is, if there is an alternative position available within the skill set of the employee, it should be offered to the employee, even if the comp and ben package is lower or smaller, and even if the job title or job role itself is of a less important role or lower in the organizational hierarchy. And in fact, the courts have gone so far as to say that if some amount of retraining is required to enable the employee to discharge that role, the company must provide it. And I just want to stress something here. I've noticed that with many multinational companies, especially those with a head office in the US, the common practice is to invite the employee to check on their internal, website or data bank or whatever for available positions and apply for the role if they are interested. That is not discharging the obligation to offer alternative employment. And neither is it acceptable to ask the employee to attend interviews and compete with external candidates. See, the whole idea is the employer is supposed to identify the best suited role and give it to the employee. It's not to tell him, look, if you are interested, you apply. Sorry?
Yeah, that's really interesting. So it's not like go check the availability of job vacancies within the group. You have to present the job to the individual.
That's right.
And you cannot interview other candidates for it.
Not until this employee rejects the role.
Wow. Okay, that's really interesting, Sal. Thank you. Thank you for that. Gagan, may I turn to you? For India, how are the evolving labor law reforms reshaping the approach to workforce restructuring? And to follow, what changes should multinational employers anticipate?
Thank you, Catherine, for this very important question about evolving labor reforms in India. Let me share some crucial insights about how India's labor codes are reshaping workforce restructuring, particularly drawing from our practical experience. The essence of these changes lies in the Industrial Relations Code, which is a new code which replacing the Industrial Disputes Act, which fundamentally alters how we look at restructuring. For the first time, we are seeing integrated provisions that consider technological advancements and market conditions as legitimate grounds for reorganization. Now it is in black and white. This is particularly relevant when companies are adapting to changes like AI and automation. I think India is getting ready for that, such kind of reforms. What's fascinating in the new framework is also that it's a treatment of establishments. For example, if your company has different units handling various aspects of business, these might now be treated as one establishment if they have integrated operations. So this single change significantly impacts restructuring strategies, particularly around approval requirements. So this law has been built over various courts judgments around the gray areas where industry employers used to, take that approach that no, we are a single undertaking out of the many undertakings we have in one office. So all these are being addressed in the new code so that there are less disputes, labor disputes or trade union disputes with the employer. So the practical approach we are seeing successful companies adopt is threefold under the new codes which are coming up. Firstly, they are focusing on proper documentation of a business rationale of redundancy. This isn't just about paperwork, but about building a clear narrative of what is triggering such redundancies. Second, they are introducing voluntary separation options before considering involuntary reductions. And third, they are also ensuring clear communications throughout the process. So an interesting development under the Social Security Code, for example, is the introduction of a reskilling fund contribution, which talks about 15 days wages for every retrenched worker. So this shows how the reforms are balancing business flexibility with workforce protection. Speaking of protection, let me highlight some crucial about employee classification that's often overlooked. Under the new codes, the focus has shifted to examining the predominant nature of duties rather than designation or salaries. So this predominant nature of duties is coming out of the court decisions, which is not probably mentioned in the existing Industrial Disputes Act. So this is now being written in black and white in the new codes. So this means that the way we use, the chance of interpreting and assuming certain qualifications as workmen would require now careful reconsideration by the employers. So the reforms are also bringing standardization through the code on wages, particularly in how we calculate separation benefits. Initially, while calculating the retrenchment compensation for workmen employees, we used to calculate their retrenchment based on their basic pay. Now, many companies used to keep the component of basic pay to be very low. So that it actually impacted the retrenchment compensation. But the new code makes it mandatory for every employer to have wages which would have at least 50% of the allowances as part of the total remuneration as the basic pay. So this would really going to impact the retrenchment compensations to be paid by employers in the near future. So looking ahead, what should multinational employers anticipate under the labor reforms in India? I believe the key lies in understanding that while these codes aim for national standardization, state-specific nuances will continue to play a very crucial role. So this means developing flexible yet compliant approaches to restructuring. Thank you.
Thank you, Gagan. Thank you. That's very insightful with the new code. So turning back to China, where is Bo? What is the general and practical approach to workforce reduction in China?
Yeah, thanks, Catherine. So as mentioned earlier, so in reality, the most suggested approach would be, a combination of the mutually agreed termination as the primary approach, while with an appropriate unilateral termination being the backup plan, so that, for the employees who you cannot reach an agreement with, you can then terminate them unilaterally. Well, I think in reality, the good news is that in most cases, the majority or almost all of the employees will choose to sign the agreement. But of course, the key factor to incentivize the employee to sign the mutual agreement will be subject to the severance compensation. And I think in general, the severance compensation includes three parts. The first part is the mandatory severance. The mandatory severance is quite clear, and it is based on the number of employees' service years at the rate of 1 month's salary for 1 year of service. And also the monthly salary is subject to a cap, which is, I think, generally around US dollar 5,500 across the nation. So the second part is the ex gratia compensation, which generally ranges from 2 to 6 months salary without any cap. But of course, in reality, it could be lower and could be also higher depending on the real situation, and the factors may include how historically the companies have done termination or layoff cases, and also how the companies in the same industries have done that, as well as how difficult are those employees of the impacted employees to be negotiated with. But in general, 2 to 6 months would be a rough range that is applicable, like universally in China. And then the third part would be any other contractual benefits, such as incentive plans, a deferred bonus, and also profit sharing plan, compensation of untaken annual leave, etc. So basically, if you are to summarize, if the companies are proposing a fairly reasonable severance compensation package, the difficulty of reaching an agreement with the employees would be quite low.
Thank you, Bo.
Yeah.
So, did you have something else to add?
Well, no, that's it. Yeah.
No, I was just gonna say that it almost seems like the severance payment or the ex gratia compensation is more an art than a science, because you have to mention, it's based on what have we done in the past, what are people in the same industry doing, how difficult you anticipate your employees will be, and then come to some sort of financial proposal. So it's definitely, well, it seems to me that it's more an art than science. Thank you, Bo. Thank you. And Chris, what is the general and practical approach to workforce reduction in Korea?
Well, I think it's important to bear in mind that in Korea, there's just no particular set of standard procedures you can follow to make laying off employees legal. Like I mentioned before, often layoffs, meaning unilateral termination for redundancy, is just not realistic at all. And any kind of downsizing will have to rely on buyouts and other personnel measures, and a bit of creativity. And then sometimes layoffs might be viable, but they're always subject to considerable risk and uncertainty, even if you think you have a legal case for it. So every project really has to be reviewed based on its own circumstances to come up with the best possible approach. And where you are able to use unilateral terminations, where it's plausible enough to do that, it's going to require significant advanced planning to address the local requirements and be prepared. And in any case, restructuring is often going to be very costly and time-consuming in Korea, particularly compared to some other jurisdictions. And the exit packages can be very high here. I mean, there's a lot of variation, and I echo everything you were just saying about it being an art and having to look at past practice and industry practice. That's often necessary. But at the higher end, you can have packages where long-serving employees get several years' pay, and that's on top of statutory severance benefits that all employees with a year of service or more are entitled to. So the amount of money involved can be very substantial.
Well, thanks, Chris. Well, speaking of money, I think it might be interesting for our attendees to get an idea of what termination payments would look like when companies are restructuring across the region. And perhaps we'll go to Gladys first. So what kind of payments would an employee typically be entitled to in cases of a redundancy in Hong Kong?
Thanks, Catherine. In Hong Kong, employees who are terminated for redundancy are entitled to the same severance payment, regardless of whether the redundancy is individual or collective. So for redundancy, the termination payments include payment of wages in lieu of notice if the employer wishes to pay out notice, final month's wages, accrued but untaken annual leave, statutory severance payment if it's applicable, to the employee's tenure and any other contractual payments such as contractual bonus, and this would be determined by looking at the terms of the employment contract.
Thanks, Gladys. And coming right back to you, Chris, what are the typical payments that employers would need to make?
It feels like a lightning round. Yeah, I mean, in Korea, because the law doesn't really care whether redundancies are collective or individual terminations, basically the law just cares why is somebody terminated, and if they're terminated for business reasons as opposed to misconduct or poor performance, there has to be those factors I mentioned earlier satisfied, an urgent business necessity and those procedural requirements. The number of employees kind of doesn't matter. It only matters for the purposes of certain reporting requirements. But when we're terminating a significant number of people for redundancies, it can affect the amount of money that it may cost, the kinds of payments that would have to be made. Often the package is a standard offer in what's called a voluntary separation plan or something like that when we're doing a larger scale exit, as opposed to individually negotiated packages with individual employees. Unless there's any kind of collective bargaining agreement or policy, then basically there are standard minimum termination payments that are required. There's statutory severance benefits in Korea. Any employee with a year of service or longer accrues these severance benefits. It can be a lump sum payment that's according to a formula. It's kind of roughly 1 month salary per year of service, although it's not really that. It's a bit more complicated. And there can also be a pension in place to satisfy this obligation to provide severance benefits, which can be defined contribution. So contributions are made to the employee's accounts regularly, again, according to a minimum statutory formula, or it can be a defined benefit pension. And unused leave generally also has to be encashed. And then on top of that, you have an ex gratia payment, which is to convince employees to leave, which is basically mandatory in almost every case, at least to try. And that payment is very variable. It can be extremely high. It can be more reasonable. It depends a lot on the factors you were talking about earlier, Catherine, which can include just how difficult the employees are. And that's basically mandatory to try and agree on that kind of payment because of how difficult it is to unilaterally terminate employees.
Thanks, Chris. Over to you, Krista. Same question.
Yeah, the Fair Work Act provides employees with a minimum entitlement to redundancy pay in all cases where the company has more than 15 employees. There's no additional payments on that collective basis like we've heard in some of the other Asia-Pac regions. But the statutory entitlements certainly can be enhanced and often are through a deed of release, again, with ex gratia or more additional discretionary redundancy payments. Certainly collective agreements can and often do have more beneficial redundancy terms in them. And severance pay is made to eligible employees in addition to obviously notice if it's paid out in lieu, any unused accrued annual leave and any long service leave that's owing to that employee by virtue of their tenure.
Thanks, Krista. And over to you, Hannah, for New Zealand.
Yes, Catherine, interestingly, New Zealand law does not provide for any minimum entitlement to severance pay. Our government did look at this a couple of years back, and there were murmurs of there being a change, but that has not happened. So currently, as the law stands, any redundancy payments would be governed by the terms of the individual or collective employment agreement, or sometimes employer policies as well. Now, because these payments are entirely contractual, we do see a variety in terms of quantum. Often it is the case that there is no severance pay or no redundancy compensation to be provided, only a period of notice. Other times there is an entitlement to compensation. 1 month's pay is a fairly common amount for smaller employers in the private sector, but some agreements, particularly collective agreements and older collective agreements, will use a service-based calculation. So, for example, 4 weeks pay for the first year of service, and then maybe a week or 2 weeks for each subsequent year of service up to a certain cap.
Great, thank you, Hannah. And Yukiko, what is the position in Japan, given that you have mentioned it's quite, given that Yuka has mentioned it's quite difficult for employers to validly dismiss employees for redundancy?
Yes, actually, in terms of payment, and in case of dismissal, the only legal requirement for payment is either providing 30-day notice, advance notice, or make payment in lieu of such notice. And also, if the work rules of an individual employment contract provides a contractual payment, such as a retirement allowance, upon separation, then the employer must pay in accordance with the rules of provision in the work rules or employment agreement. But please note that the payment does not itself by any means ensure that the dismissal is legally valid. This is a procedural requirement only. So, anyway, as Yuka mentioned earlier, we have to carefully consider whether the dismissal has just cause in redundancy. 4 factors are met to demonstrate the existence of just cause. So the sudden or unexpected dismissal should always be avoided. And then so the company in Japan, in order to avoid dispute risks, typically offer voluntary resignation together with the severance package. And then the amount of severance package, there is no statutory rule or established standards. So it is totally depending on negotiation, case by case basis. However, from our experience, many companies offer at least 6 months salary or 1 month salary per year of service, whichever is higher. And depending on the company's financial situation, it is not uncommon for companies to offer 1 year's salary or more when soliciting voluntary resignations.
Thank you, Yukiko. Bo, what is the position in China regarding additional payments in the cases of collective redundancy?
Well, I think in China, in a collective redundancy scenario, there's actually no requirement for additional payment. But as I mentioned, because of the difficulties in conducting any collective redundancy in real life, it's quite rare that companies would go down the collective redundancy approach. Well, I mean, even if some companies are doing that, the primary goal would be using that as leverage to push employees to agree to the mutual agreement, to sign the mutual agreement. And in which case, what I mentioned earlier about the compensation package would apply. Yeah.
Thanks, Bo.
Yeah.
Gagan, what about India? Are there any differences between payments that would need to be made to those that are workmen or non-workmen categories of employees?
Of course, yes, this is very important. The first step is to, and even if it is a collective redundancy, we need to, the employer has to be mindful about first segregating the impacted employees to be in the category of workmen and non-workmen, because workmen are entitled to retrenchment compensation, which is 15 days salary for each completed year of service. One exception for them is that only those workmen who have served at least 1 year of employment is entitled to such compensation. In addition to that, every component of the severance package is is common for both the kind of workmen as well as for the non-workmen. Ex gratia is again an art. If it is used as an incentive for the employees to sign the mutual separation agreement, we generally advise clients that ex gratia should be offered to only those employees who agree to sign the mutual separation agreement. So this is how we plan the negotiation for our clients for smooth transition.
Thank you, Gagan. And Desmond, what is the position in Singapore? Are there minimum redundancy payments?
Thanks, Catherine. Very similar to what Hannah has shared in terms of New Zealand, there are no statutory prescriptions in terms of minimum payment amounts in a redundancy. So from a pure dollars and cents perspective, we go back to the advisory that I mentioned earlier, where the recommendation is really 2 weeks to 1 month for every year of service. The nuances to that recommendation, because it's drafted in a recommendation perspective, you kind of don't have a cap. And generally speaking, if you do see guidance from the Tripartite Alliance, they would certainly say that there shouldn't be a cap. And in terms of 2 weeks to 1 month for every year of service, the question that sometimes gets posed back to us is, what about a incomplete year of service? Do you prorate it? The answer, again, from the recommendation is no. So if it's 3 to 4 months of a year, you generally are encouraged to give that full year's allocation. Yes, generally speaking, that would be the recommendation. When you look at it from a very practical perspective, because this advisory applies from the very junior employees all the way to very senior management, companies sometimes do take a little bit more of a nuanced approach where they would try to distinguish the amount of redundancy payable to very senior management, keeping it to the lower end. And in terms of the more junior employees, then there's a greater willingness to reach the higher end of the 1 month recommendation.
I see, because I guess for the more senior staff, the more highly paid, so that would, the financial compensation would be much higher in proportion to. I see.
Exactly. So it's purely from a numbers perspective. And again, coming back to the point that because this is not statutorily mandated, and this is really from a perspective of a recommendation, where so companies feel that they are willing to honor the spirit of the recommendation, but then they manage it and from a dollars and cents aspect as well.
Understood. Thanks, Desmond. And coming back to you, Sal, could you briefly explain the 2 categories of employees when talking of minimum payments?
Sure, Catherine. So generally, in Malaysia, we have 2 categories of employees, and in as much as the Employment Act was amended in early 23 to extend the scope of its application to all employees who are employed in Malaysia, there are certain provisions that have been carved out and are still limited to employees who either earn 4,000 ringgit per month and below, or regardless of the salary that they earn, they are employed to do manual work, to supervise manual workers, or to operate or maintain vehicles. So for these categories, for employees who fall within this category, they are entitled to statutory termination benefits. And these benefits depend on the length of service that the employee has. So the minimum would be 10 days wages for each year of service. It can go up to 20 days wages for each year of service for employees who have 5 years or more. Now, for the rest of the employees, right, those who don't fall within that category, that would mean, let's say, somebody who's employed in an executive level and is earning more than 4,000 ringgit a month, there is no statutory requirement to pay termination benefits.
Right.
Having said that, I must stress that our courts have held that whenever an employee loses his job due to redundancy or by way of retrenchment, fair and reasonable benefits should be paid. And in that case, employees were paid half-month salary for each year of service. And the court said that given that the company or the employer is in a financially sound position, paid something. Apologize. And so currently the market rate is 1 month's salary for each year of service.
And is there a cap, or, you know, if you've got a senior exec that's been with the organization for 20 years, there's no cap?
No cap. Though I have to say that we have assisted clients in doing like a mass redundancy, and where certain people would end up receiving more than $500,000, then the companies have imposed a cap of $500,000. And well, it's not been challenged in court. So I can't say what the courts would say if it is challenged. But it seems fair enough if it's a massive amount.
Great, thank you, Sal. We received one question from the audience, which is for Australia, Krista. What do employers need to consider when reducing headcount, or what obligations do employers have when it comes to choosing certain employees over others for a reduced number of remaining roles?
Certainly. So in terms of consideration, firstly, for that genuine redundancy defence, usually there's a business rationale or reason, such as a financial reason or a change due to technological advancements and the like, that gives you the rationale as to why you need to reduce or right-size the headcount. When considering how you choose employees, that will depend on the circumstances. But what you can't do is choose an employee because they have a protected attribute under discrimination law. So they can't, for instance, you can't choose an employee because of any of the protected attributes that exist, such as because of their gender or their marital status or their religious or ethnic status and the like, or if they're a member of the trade union. Another reason that you can't is because they've exercised a workplace right, such as taken workers' compensation and are off ill or injured. So there's various minefields in terms of justifying how and why. In Australia, we say it's the position, not the person. And so you need to be able to justify why that position and the tasks performed by the person who's holding that position are no longer required to be performed. Often that means that you can segment or take parts of those tasks and absorb them elsewhere. And when you can demonstrate that they are absorbed elsewhere and that there is genuinely no longer a need for that position to be performed, then you're able to do it. In cases, just briefly, where there's often there might be 4 or 5 employees performing the same position and you want to reduce the headcount to, say, 2 or 3, how you can do that is either by a spill and fill, where each employee is asked to essentially apply for the remaining positions. But outside of that, you might look at it on an objective criteria basis, such as performance, attitude to the job. You could use length of tenure, although we don't typically, like Sal had indicated in Malaysia, that's typically not necessarily a ground in itself. But there's objective criteria that you can apply to determine why the specific person is impacted where their position is no longer required.
Thank you, Krista. So unfortunately, we are running out of time and our panelists don't have enough time to reply to all of your questions, but set out on this slide are our contact details. So please feel free to ask us any questions that you may have after this session. We do have a variety of resources and insights on the cross-border employment rules on our website, so don't forget to check that out. For more information on our webinars, you can visit the webinars section of our Ius Laboris website to find all the past recordings and download the slide decks. And while you are here, take a listen to our podcast, Talking Work, in which we talk about the world of work. Finally, I would like to thank everybody for attending, and thanks also to all of our panelists today for their interesting insights. And so with that, this webinar will now be coming to an end, and I hope everyone has a great rest of the week. Thank you so much. Thank you.
Thank you, Catherine.
Thank you.
Thank you and good night.
Okay.
Peter.
Bye, everyone.
Thank you, everyone.
Thank you.
Thank you, Catherine. Thank you, Flo.